In a landmark move that has captured national attention, a federal judge has authorized the release of secret grand jury materials from the Jeffrey Epstein case, breaking through years of legal barriers and silence. This decision promises a new era of transparency in one of the most infamous and far-reaching sex trafficking scandals in modern history, raising hopes for long-awaited answers. Judge Richard Berman's decision marks a dramatic reversal of his earlier stance, now aligning with recent congressional action that demands the Epstein files be made public for the sake of justice and public interest. The order covers approximately 70 pages of grand jury transcripts from Epstein's 2019 indictment, a long-sought victory for survivors, journalists, and advocates who have fought tirelessly to bring these records to light, believing they contain crucial details about Epstein's network, his methods, and possible accomplices who have so far evaded scrutiny. For years, secrecy and red tape have shielded the powerful and denied justice to victims. This ruling signals a significant shift toward accountability, transparency, and the possibility of real consequences for those involved. The release is part of a broader push for openness, with multiple court orders now accelerating the unsealing of records as a new federal law's deadline approaches, putting additional pressure on institutions to comply. As these long-hidden documents come to light, the public may finally gain unprecedented insight into the investigation's inner workings, the scope of Epstein's reach, and the mechanisms that allowed his crimes to persist for so long. The coming days promise revelations that could reshape our understanding of a conspiracy that touched the highest levels of society, and may finally offer a measure of justice to those who have waited far too long. To appreciate the significance of this unsealing, we first need to look at the long-standing traditions and rules that surround grand jury secrecy in the United States. It's important to understand why grand jury proceedings are usually secret. This secrecy isn't just a formality, it's a fundamental part of the American legal system, designed to protect the integrity of investigations and the rights of those involved. Grand juries investigate potential crimes and decide if charges are warranted, operating under strict confidentiality to protect reputations, encourage honest testimony, and prevent interference. Witnesses may be more willing to speak freely, knowing their words won't be made public unless charges are filed. Breaking the secrecy is rare and requires a compelling public interest. Courts are extremely cautious, weighing the risks of disclosure against the benefits to society. In the Epstein case, the scale of the crimes and persistent questions about powerful individuals created extraordinary pressure for transparency. The public's demand for answers grew louder as more details emerged. Recent court orders mark a dramatic departure from legal tradition, driven by new federal legislation and overwhelming public demand. Lawmakers and advocacy groups argued that secrecy was no longer serving justice in this case. Judges now recognize that continued secrecy does more harm than disclosure, especially since Epstein is deceased and many alleged victims are seeking closure. This shift sets a precedent for openness in cases where public accountability outweighs the need for confidentiality. It signals a willingness to adapt legal traditions to meet the demands of justice and transparency. The Epstein saga has become a unique exception, paving the way for unprecedented access to grand jury records. Legal scholars are watching closely to see how this will influence future cases. The result, a new era of transparency in the justice system's handling of high-profile crimes, and a reminder that the law can evolve in response to society's call for accountability. The push for transparency is fueled by the Epstein Files Transparency Act, passed by Congress in November 2025. This law compels the Department of Justice to release all unclassified Epstein-related records, internal memos, investigative reports, and more by December 19, 2025. The act was a response to years of frustration over government secrecy and slow disclosure. By setting a firm deadline and mandating online publication, Congress forced the DOJ to act quickly and decisively. The law also gave judges the authority to unseal grand jury materials, overriding previous hesitations. Now, the judiciary and Congress are united in demanding full disclosure, ensuring the public finally gets answers. The countdown to the release has begun, marking a turning point in the fight for accountability. Judge Berman's order is just one in a series of rapid-fire court decisions clearing the way for the release of Epstein-related files. In just over a week, 3 federal judges have approved DOJ motions to unseal records from different phases of the Epstein investigation. These include grand jury transcripts from the 2019 Epstein case, the Ghislaine Maxwell prosecution, and the earlier, abandoned Florida probe. The release of these documents will provide a sweeping view of Epstein's criminal enterprise and the government's response over decades. The DOJ's coordinated legal strategy reflects a systematic effort to meet the new law's requirements before the looming deadline. This synchronized approach ensures that the public will soon have access to a comprehensive archive of the Epstein saga. The stage is set for one of the most significant document releases in recent memory. While the courts have authorized these releases, judges have cautioned that the documents may not contain shocking new revelations. Judge Berman, after reviewing the 2019 grand jury materials, noted they offer little that's explosive, managing expectations for those hoping for bombshells. Previous document releases, like those from the Virginia Giuffre lawsuit, named many prominent figures, but rarely provided definitive evidence of wrongdoing. The real value lies in the procedural details and sworn testimony, which help clarify the government's case and dispel rumors. The process of uncovering the full truth will be incremental, requiring careful analysis by journalists and researchers. The significance of these releases will come from the cumulative evidence, not a single smoking gun. Even so, these official records are vital for understanding the scope of Epstein's crimes and the justice system's response. The mosaic of information from multiple releases will gradually reveal the broader story. As the DOJ prepares to release thousands of pages, protecting the privacy of Epstein's survivors remains paramount. The new law and court orders require careful redaction of names, addresses, and any details that could identify victims. The DOJ is working closely with survivors and their attorneys to ensure no further harm is done. Explicit images and sensitive materials will be strictly withheld, in line with legal and ethical standards. The goal is to expose Epstein's network without re-traumatizing those he abused. This balancing act is central to the transparency effort. Justice for victims must not come at the cost of their dignity. The DOJ's commitment to thorough redaction is a crucial measure of the process's success. Ultimately, the release aims to serve the public interest while safeguarding those most affected. Jeffrey Epstein's story is one of unchecked power, systemic abuse, and decades of evasion. For years he exploited vulnerable girls across multiple states, protected by wealth and influential connections. The first major investigation in Florida ended with a controversial 2008 non-prosecution agreement, allowing Epstein to serve minimal jail time and shielding his associates. Investigative journalism and survivor advocacy kept the case alive, leading to Epstein's 2019 arrest in New York on new sex trafficking charges. Hopes for justice were dashed when Epstein died by suicide in jail, leaving many questions unanswered. His death fueled conspiracy theories and intensified demands for a full accounting of his crimes and the failures of the justice system. The push for transparency is rooted in the public's frustration with years of secrecy and missed opportunities for justice. Now, the unsealing of records offers a chance to finally confront the truth. With Epstein gone, attention turned to Ghislaine Maxwell, his closest associate and alleged chief recruiter. Survivors describe Maxwell as instrumental in grooming and delivering victims to Epstein. Arrested in 2020, Maxwell was convicted in 2021 on multiple counts, including sex trafficking of minors, and sentenced to 20 years in prison. As grand jury records from her case are set to be unsealed, Maxwell's legal team has taken a neutral stance, aware that opposing transparency is futile. Her lawyers have expressed concern that the release could impact future legal appeals, but have not formally objected. The momentum for disclosure is now overwhelming, driven by new laws and public demand. Maxwell's conviction and the coming document releases mark a significant step in the pursuit of justice for survivors. The focus now shifts to what the unsealed files will reveal about her role in the broader network. With the December 19th deadline rapidly approaching, the Department of Justice is working around the clock to finalize the review and redaction of thousands of Epstein-related documents. This process involves meticulous attention to detail, as officials carefully determine what information can be made public and what must remain confidential to protect ongoing investigations and the privacy of individuals involved. Soon, these files will be published online in a searchable, downloadable format, giving the public unprecedented access to a trove of information that was previously hidden from view. For the first time, anyone will be able to explore the documents, search for names, and follow the paper trail themselves. Journalists, researchers, and advocates across the country will comb through the records, piecing together new details and connections that could reshape our understanding of the case. Their work will be crucial in uncovering hidden truths and holding powerful figures accountable. The process will be painstaking and time-consuming, with the story unfolding gradually over weeks and months as the vast amount of material is analyzed, cross-referenced, and discussed in the public sphere. While it's unlikely that a single smoking gun will emerge, the cumulative evidence revealed in these documents will deepen our understanding of Epstein's crimes, his network, and the justice system's failures to stop him sooner. This release is a milestone in the long fight for truth and accountability, driven by the courage of survivors and the relentless demand from the public for answers. Their voices have made this moment possible. The unsealing of these files marks not the end, but the beginning of a new chapter in the search for justice. It is a turning point that will shape the conversation for years to come. The world is watching as the secrets of the Epstein case are finally brought to light, and the impact of this release will be felt far beyond the courtroom.